So my name is Christopher Gusman, former special education administrator and principal, currently a teacher leader in Fall River. Officially, it's called an interventionist. We just did special ed sort of 101. The biggest part of special education, especially for those with emotional impairments, is rather this portion, which is special education and discipline. What I will go through is generally speaking for all students, what is discipline, and you'll notice the parts that are with special education and with a sort of only special education and things that happen. So according to Goss v. Lopez, all students are entitled to due process prior to being excluded or expelled, which is very different than excluded. The amount of due process is determined by the length of exclusion, whether that's 10 or more or less than 10, which is short versus long. Now, Mass General Law, Chapter 71, Subsection 37H, and they have split 37H a lot of ways. And you're going to laugh if you've never seen this specifically. 37H deals with weapons, drugs, and assault. So a principal has the authority to permanently expel a student for possession of a dangerous weapon, controlled substances, or assault on a staff member. So the Chapter 94C talks about what specifically those controlled substances are, because in Massachusetts, they're probably a little bit different than if you've come from Texas like I have, where controlled substances are defined a little bit more strict. Now, for students, and you'll notice this little sort of rectangular sort of box throughout the presentation from here on out. If we're talking about a student with a disability, a dangerous weapon is as defined in the US Code, okay? So the difference between a dangerous weapon for a regular ed student is different than a dangerous weapon with regard to a student with a disability. Just as an example, if a regular ed student brings a water gun to school, plastic, green, in some areas of the state, this state as well as throughout the country, that's considered a dangerous weapon, not because it's a water gun, but because it's a gun and they have what's called a zero tolerance. Now, if we're talking about a student with a disability, that dangerous weapon is defined according to US code, and it's more about what we think about as a dangerous weapon, where we're talking about AR-15s or anything like that. So it's very different, and it can literally be at opposite ends of the spectrum. So that's 37H, and here's where we start the funny part. Oh, sorry, that's a little bit later. Prior to imposing long-term suspension, student always has the right to counsel at their own expense. Examining evidence against the student, it's almost like a court of law, and to present evidence in their own defense. And always, just like with the IEPs, you can always appeal the decision in writing to the superintendent or their designee within 10 calendar days. All right, here's where we get to the fractions. This is 37H and a half, where we talk about felony charges. There's two basic columns here. There's the charge that can give you a suspension, and there's a felony charge that can give you an expulsion. So the easy one is essentially where they are charged, and that's it. nothing else, just charge. So after they're charged, the principal says, is the student's presence in school, does it have a detrimental effect on the welfare of the school in general? If they are convicted of a felony, so this is a conviction, adjudication, or the student admits it in court, very specific wording there, then they can be expelled from the school versus just suspended. So, and again, they have the right to counsel evidence, present evidence in their own defense. And the principal must provide written notice of charges and basis for decision prior to imposition of a suspension and notice of appeal process. So I will say that most districts have forms, essentially insert name here, address, student name. This is what was found on the student. And then it's a form letter. So it's terrible to say, but it's very generic for this specific, and most parents receive. So that's 37H. Now, to get into sort of discipline as it's defined by Massachusetts 603 CMR subsection 53.02, in-school suspension. So for these, in special education specifically, any removal from the classroom time is in what we kind of think about is suspension, okay? Whether that's in school, so you come in school, don't go to class, you have to go to a separate setting. That is time away from learning for special education. For regular education, not necessarily. It still counts as seat time, not for special education. So in-school suspension on school premises can't be more than 10 consecutive days or 10 days cumulatively for multiple infractions. Essentially, once you get to 10, then you have to be short-term suspended out of school. Long-term suspension, which we'll talk about relative to special education in a few minutes, but 10 consecutive days, no more than 10 or more than 10 cumulatively for multiple offenses. Expulsion is removal for more than 90 days or indefinitely or permanently as permitted by 37H, 37H and a half. Now, I want to go over the FBA just very quickly because we're going to kind of talk about it intermittently throughout, and it kind of goes with the definitions. In short, it's an assessment done to figure out behaviors and to develop interventions to improve or eliminate the behaviors. And there's a lot more sort of to it, but that's really sort of very targeted statement about really what an FBA is. It's an evaluation that gets to what is causing the behavior and how to fix, and I put that in kind of quotes, or to lessen the behavior to increase the academic outcome. So identify environmental antecedents, figure out consequences, or methods of sort of using cognitive behavioral approach where if I know that math makes me very anxious, then before math gets started, I need to take a lap. Or during math, I need to take a lap because math makes my heart beat really fast. I start sweating, whatever. It's important that we address sort of the internal in order to get academics out of a student. So that's sort of a simplistic view of an FBA, or functional behavioral analysis. Now, emergency removal. So a lot of times we have and this is where a student makes or does something that is harmful or detrimental to the school setting. This is out of what we've just talked about with regard to assaults, weapons, or drugs. So a principal can remove a student for up to 2 days without a hearing if they're so essentially if they do something wrong, and has to be, that's red is, I mean, it's an orange, so, and the continued presence of the student poses a danger to persons or property that would substantially and materially disrupt the order of the school, and in the principal's judgment, if there is no alternative available to alleviate the danger or disruption. So, in short, if a principal thinks that they've done or said something, even if the student says it was in jest, so I'm going to blow up the school. That is a 50, that's something that would be reported to the office. And, they're laughing, the teacher overhears it. As a mandated reporter, they have to say something, regardless of whether it was in jest or not. That would be a reason for a principal to call an emergency removal. So, because that would, in essence, even if they were or weren't, it's concerning. That's an extreme example, but I just kind of wanted to get across my point. Immediate and reasonable efforts to orally, so they have to call, they can't just send them home. They have to call, whatever, they can't just send them home. Now, and this is a really important part, especially for parents, especially if your student has emotional disabilities, behavioral disabilities. You do not, as a parent, have to leave your job or leave wherever to get your child when they say must come and get them. So that's something that not everybody knows. You can say, I will be there when I can. And if that's 5 minutes before the bell rings for dismissal, it is 5 minutes before the bell rings. They have to make adequate provisions for the student's safety and transportation. Now, if you want to go and get them, of course, go get them. If you're in the middle of work and you're going to get out in 2 hours and you're going to get there in appropriate time, wait. They have to ensure that student's responsibility. I'm sorry, they have to ensure that students' safety as well as the safety of other students. So if for whatever reason they say, well, we need you here so that the police can do whatever they need to do, then you have to make a reasonable determination. However, a lot of parents don't know that you don't have to just jump in your car and go get them ASAP. You can also essentially say, if you, again, this is, your child more than anyone, you can say he can walk home. And some districts will allow that. And that's a conversation between parent and administrator. So, and I've had that happen too. So, do I have any questions so far? I know this is really like mundane and legal, but I think it's necessary to really truly understand what's going on. Let me just make sure I didn't skip one. Okay. Academic progress and disciplinary removal. So if your student is suspended in school, out of school, short-term, long-term, anything, under any rule, 37H, 37H and a half, and 37H and 3/4, I'm not joking with the last one. It's really a thing. Your student has to be able to make up every assignment, paper, schoolwork, test, so that that student makes academic progress. And that is during their removal from the classroom and or school. If it's for an extended period, they, or rather the student, has to get a tutor that is provided by the district at the district's expense. They have to allow the student to make academic progress. Now, if the student refuses, if the student doesn't do the assignments, the tutor simply has to go if they don't show up, or generally they arrange for somewhere for the tutor to meet at the library, at some open area. Now with COVID, it's a little bit different, but and really it's just an open area that is public. In a lot of special education cases, they do go to the home, which is an option. All parties are okay with it. But they have to allow for academic progress to happen, regardless of type of suspension or exclusion. Now, here's where we go. Students with disabilities are entitled to additional protections before discipline actions happen. Okay, so these are, and students with disabilities include 504s and IEPs, and those that might be eligible for special education. If your student is currently in progress for being tested because they have extreme anxiety and they blow up, and they blew up at a teacher and they said things that maybe they shouldn't have, then that could be covered under IDEA or under Section 504. So that the students with disabilities is also a might. They might have a disability. Did somebody have a question? All right. So again, if you do have a question, and you can either type it in the chat box or hit Q, and then I'll see a little chat icon, I think. So anyway. Additional procedural protections. So if your student is removed from the school setting for a long time, and that includes if they're on their 6th day of suspension, and a suspension isn't always a suspension the way we think about it. It could be that your student is asked to go home, come get your child now, and it's noon. Well, guess what? That counts. If your child is asked to go home, if your child is not let's say they're breaking a uniform policy. So you can't wear green to school. Your student wears a green suit. You can't come in here with a suit. I'm not taking it off. So then you have to go home. Well, if I'm going home, I'm not coming back. Okay, there you go. See ya. That's counted as removing that student from school. And a lot of people, that's again, not everybody knows that. Whenever appropriate, they have to do an FBA, functional behavioral assessment, an FBA. And it just looks at the behavior. It creates a behavior plan, which generally are really helpful, especially for new teachers or teachers that may not have had the student. The new school year starts, mid-semester, they change classes, things like that. It's really, really helpful for teachers to understand what students' triggers are, different things like that. So for students with IEPs, the provision of services as the 11th cumulative day of removal. So like I was saying earlier, if your student has had 5 suspensions or whatever, excluded, 5 days excluded for whatever reason, and they get suspended for 5 days, there has to be a manifestation done. So anytime you get to that 10-day, a lot of districts like to do it around the 9th, just in case something happens, essentially just in case. I always did them at 8 because of the 2. If I have to do a suspension and emergency removal and it's 2 days, I need to make sure that that manifestation has covered all prior occurrences, and I know which ones were a result of their disability and which ones weren't. Every district and every principal is different. And it just kind of, you have to know, and if behavior is an issue and suspensions are an issue, then I would definitely meet with the principal or vice principal, whomever, in addition to the special education teacher that they are assigned to. So a disciplinary change in placement. This is really, really big deal. So there's a few of them. It's a disciplinary action that results in removal for more than 10 consecutive school days. A pattern of removal totaling more than 10 days. So you have a student that likes to cuss out their teacher. Happens a lot. And they're suspended every time. And you're noticing that it's happening every Wednesday when it rains. And you notice that it's going to be a really, really rainy spring. Then you need to have a plan in place, and that's what is going to be that manifestation, because the disciplinary change in placement is that pattern. It's going to rain every Wednesday for the next 8 weeks. So I know that I'm going to have to keep my student home. And that's the pattern. And again, I kind of go to extremes to accentuate what it is, but if there's a pattern happening, then it's sort of easy to tell that we're going to get to more than 10 days in the school year. And that's in the school year. So any questions so far? And a disciplinary change in placement is essentially like them saying your child is now going to go to a different school completely. It's in sort of the special ed realm, it's the same thing. One is just punitive, I guess discipline is more punitive. So talk about a little bit more with regard to manifestation determination. So 2 big questions. Was the conduct caused directly or substantially by the disability? And was the conduct a result of the student's failure to implement the IEP? Sorry, guys. So it's a team decision, and the decision, and not just the decision of the administrator or school staff. My dog is very friendly right now, which means, anyway, I apologize. But it's my buster, I love it. So that's a really, really big deal. If you know that they have bad mornings, and I know this because it's happened to several students that I've helped over the past 20 years. But in short, I've had students that can't handle mornings, and for whatever reason, they're triggered, and their preferred staff may not be available. Sorry, my dog is really being clingy right now. So occasionally they were suspended for that reason, because they blew up. They said things that they really shouldn't have. It was not appropriate, and I couldn't validate an appropriate reason to keep them for the day, or I had them sit out. So in short, we do have that it is not the decision of the administrator. So it's a team decision, and we have to take it as a team decision, and so does the district, and sometimes they don't like that. Sorry, I apologize. My dog is just not the best right now. Let's see. So is the behavior a manifestation? So let's say it's not. Then they can impose disciplinary actions or sanctions applicable as if it were any student or all students. The team does consider whether it would be appropriate to conduct an FBA, or functional behavioral analysis assessment. If and when the student is past that 10th day, they do have to ensure that special education and related services. So if the student gets if the student gets occupational therapy or speech and language or any of sort of those related services that are provided by the district, they have to ensure that your student receives those services as of the 11th cumulative day of removal. So if they've already gotten 10 or 9 and they're suspended for another 5 on that 11th day, they have to make sure that those services are in place while the student is not there. Now, somebody brought up if they can't find a speech and language, what they have to do is when they come back, that time has to be made up. So let's say they're gone for 10 calendar days, then they have to provide in a relatively short and appropriate amount of time the services that would have been performed in those 10 calendar days that the student was out. Now, if it is in fact if the behavior is a manifestation of their disability, then the team has to develop a functional behavioral assessment. Now, whenever I say the team, there's generally a member of the team that's a school psychologist, that's a behavioral, and like a BCBA, that this is what they do. This is their position in the district. Generally, it's a district position, or if, like one high school, for every 1,000 students, they might have one BCBA. So after the behavioral assessment is done, the child returns before the 11th day, unless there's consent, a hearing off, essentially a court order, or a temporary restraining order. So that is whenever the courts get involved, or the police. But in short, just the biggest part, and I'm sorry about this, but I just want to go back, is for special education, everything is pretty much the same. You always want to make sure your student has work. Ensure that, and a lot of times administrators will go to the emergency removal because honestly it's easier and there are less forms that they have to fill out. Even if they do, in order to protect your students' academic rights, especially if they're on an IEP, if they're on a 504, or if the school knows that they're having emotional issues, and that's a big thing. then there's lots of stuff that can be done. There always has to be notice. They have to send you a notice for everything. And if you don't receive a notice and they call you and say, Johnny was suspended, he showed up at school, now he's going to be suspended for even longer because he's not allowed, you can be like, well, I didn't get a call. Nobody told me. There was no email. There was nothing. So ensure that there's appropriate communication from the school if you're a parent, if you're a teacher, and you're concerned about a student that is essentially getting in trouble for the same thing over and over and over again. That may be disability related. If you're a parent and your student is getting in trouble for the exact same thing over and over and over again, then there needs to be a conversation between you and the school, you and the teacher. What's happening? Why is it happening? What is the child doing? What's happening with the teacher? You know, we just kind of, like I said before, it's all a big circle. And then with regard to determining if it was their disability, then it's a team decision. You do not have to accept what the district says. Just like, okay, I guess so, I guess I have to do it. No, it's a team decision. It's always a team decision when students are on an IEP, if students are on a 504. So, do I have any questions? Oh, oops, sorry. Wrong button. So this one was a little bit faster because it's pretty much, it's a little bit more black and white and there's less to it. So, yes, ma'am.
When it comes to disciplinary actions, do teachers or administrators have any latitude to assess the situation on an individual basis, or are they just bound by a set of guidelines that determine an outcome in advance?
There's a lot of latitude, and it's usually classified in 4 sections. There's essentially the same infraction, and if you think about I'm immediately going to a quadrant because I'm a math teacher, but it's a rubric, and you kind of just check off. And if it's a student's first time, if it's yelling at the teacher, that could be a conversation between an administrator. If the student has yelled at this teacher and has included the F word 7 times every day in the last 10 days, then it's beyond sort of that, then it kind of progresses. So it's really, they have to look at the whole history of the student. And I think that for some students with behavioral disabilities or emotional disabilities, where they have difficulty controlling their outbursts, then they may receive not as, I guess the discipline may be less, will most definitely be less, because that's just, and the administrator will know, should know. I'm not going to say will know. They should know the student's IEP. A lot of districts will send, or not send, they will have this, if the student receives significant services, they will send that student directly to the school psychologist or the student adjustment counselor instead of sending them to the assistant principal, who is sort of in a sense the disciplinarian. Now, if the student adjustment counselor sees that this is a discipline issue, then they'll all have a conversation. And sort of the student may not know this, and the parents may not know this, but there's always conversation had before and after the fact of, this student has done this multiple times. This time they were angry and they just said it and they knew that they were wrong. That's that's that different level. That's there could be a suspension involved then. Versus it was truly a disability and they didn't understand that it was actually happening, which I've had before. Students aren't in full control of themselves sometimes. Um, and that's a professional, that's a professional decision. And what do people see? What was a special education teacher? Um, I guess what interventions were done? Was there de-escalation? Was there, any physical contact between parties? So there is latitude. There is greater latitude for students with disabilities, especially if there's documentation to support it.
I'm
Yes.
wondering how, I mean, we're hopefully moving back to in-person learning, how they've dealt with these issues during the past year, like when you're in sort of your Zoom. I read this thing online about a mother whose child was home in remote school, but got a detention. The child got a detention, and then they sent a link to the mother for the child to go to detention somewhere else. I mean, and so obviously it's not necessarily the same thing as major issues of discipline, but I'm just wondering how systems have adapted over the past year to these issues, and so the same rules apply. Obviously, if they're not physically together, it's not maybe a danger of physical presence, but you could make threats online and
Right. Yes. So I guess the cyberbullying is something that was, it's probably around 5 years old, I think, is when it really sort of came to the forefront. I remember having to deal with it as a principal. And it's very difficult to deal with unless I happen to have students that were really just upfront and honestly, one of them said, I just don't give a shit. Yeah, I did it. Okay, so that was the level of kids that I had. But so 5 years ago, it came to happen. And now things are more easily understood. We have better tracking systems. Our district gives out Chromebooks to every student, but it keeps the students have no way of deleting history, creating different whatevers. So they can't, like, our computers keep everything. And I think that a lot of districts have that capability. But as far as students coming back, the students with the greatest issues have been in school the longest. I guess they're the students like in the sub-separate classes where we have, or the students that are in, sub-separate for whatever reason, whether it's emotional, academic, or health related. So they've been receiving significant number of face-to-face hours versus those that have even been hybrid. We are finding that the issue is more students reluctant to participate and engage when they're in person now, versus sort of overt behaviors. The overt behaviors are sort of easily taken care of. And I work at an alternative school. And our biggest sort of overt behaviors are happening in the sub-separate classrooms where we have students with emotional difficulties. And they've been in school the longest. So that's just sort of things that are normal for that classroom. But as far as like special education students in the special education classroom, they have been receiving more services, I guess more individualized services during this remote time than probably compared to whenever they were in person. I know our students have, because there's more opportunities for teachers to call and for teachers to do one-on-one tutoring. We even have after school tutoring where I get on Google calls and we all do for 2 hours every day. And it's just one-on-one time. So lots of opportunities are happening for districts or for students in their district, regardless of income level. A lot of times what happens is that there's this sort of, the very poor districts get lots of money and funding, and so their students get extra help. And the very wealthy districts already have lots of money, so they always get extra help. And then it's sort of those in the middle. But now with the pandemic, everybody's getting lots of money. So everybody's getting all of these services sort of overall, which is a great thing, I think. But students are, it's more of an engagement issue, I think. So that's my personal view.
Thank you.
Awesome. All right. Does anybody have any other questions before we break for a few minutes before our next session? All right, great. So Daniel, if you want to